when you secure a damages award or settlement for an injured client, it is tempting to view the job as done once quantum is resolved. But for a significant cohort of clients, the most consequential threat to that recovery has not yet materialised, and it sits squarely outside the field of personal injury law. That threat is family breakdown. The common assumption that a personal injury payment belongs to the injured person and is therefore safe from a property division if the relationship later ends is wrong. A personal injury payment is not automatically excluded from the property pool available for division between separating parties. The court is expressly directed to identify the existing legal and equitable rights and interests in the party's property. The emphasis on existing interests has narrowed the pool to property that legally or physically exists at the time of hearing. The court then assesses contributions under section 79.4 and finally weighs the party's current and future circumstances under section 79.5. That last provision matters a great deal here. Section 79.5 considers a party's age, state of health, and future earning capacity. Precisely the circumstances a seriously injured client embodies. A lump sum intended to fund decades of care can be exposed if it has been spent to jointly held assets. Conversely, a sum that has been kept identifiable and used consistently with its purpose stands on stronger ground. The point is that the outcome is rarely automatic and is heavily influenced by decisions made long before any separation is contemplated. The risk this creates is both real and avoidable. A client who receives a substantial settlement and then separates 12 or 18 months later may discover that funds meant to sustain them for the rest of their life have become contestable. The carer spouse who gave up employment to look after the injured party faces their own financial vulnerability from the other direction. Either way, the value of the work you did to secure the recovery can be eroded by a problem you were well placed to flag but were never asked to address. The protective mechanisms exist, but they are most effective when implemented before settlement is finalised, not after a relationship is broken down. For example, a binding financial agreement can quarantine compensation funds from a future property division, provided it is properly drafted and the procedural safeguards, including independent legal advice for each party, are met. Keeping a settlement identifiable rather than intermingling it preserves the arguments available later. None of this is within the personal injury lawyer's remit to execute, but recognising when it is needed very much is. When you act for an injured client whose circumstances raise the flags, a vulnerable marriage, a blended family, a carer spouse who has foregone employment, or simply a large award heading into an uncertain domestic situation. An early referral to a family lawyer is not a distraction from the compensation claim. It is part of protecting the recovery you have worked to secure.